Hi, my name is Rikisha D and I am an attorney in the state of California, and I have been practicing law for almost 10 years. This is an informational only video, and I would like to actually take the time and let you know that if you would like further legal advice, please feel free to contact my office so that we can go ahead and provide you with that information. Next, let's discuss property division. We have two types of property. We have separate property. That's actually property that possibly you've inherited before the marriage or during the marriage. That's property that you came into the marriage with. Then we also have what you're called community property. And this is property that you have accumulated together during the marriage. So you actually have to have a date of marriage in order for the community property clause to take effect. With the separate property, like I stated, you can be married, and if you alone have inherited that property, then it is still considered your separate property. Community property, that's tricky because sometimes it's not even stated as community property. It might be a community interest. Because say, for example, you buy a house before you got married. However, during the marriage, the community contributed to paying the mortgage on that house, to paying any type of repairs, investment, refinancing. Then the community has an interest. And in order to determine what the community interest is in the separate property, you basically have to do another formula. Everything requires a formula sometimes, and when it comes to a dissolution. So that's how a separate property can have a community interest. Then we have a community property. During the marriage, you guys decide to buy the house. One partner, one of the spouses, they actually are the worker, the financial provider. They work outside the home. The other party, they are stay at home. They don't work. They don't financially provide, but they provide in other ways. However, you, as someone who feels that only your money was invested into this property, that's not how the court is going to see it. This is a 50-50 situation because you got married and then you accumulated the property. So it's more than likely it's going to be 50% yours and 50% the other person's. Sometimes you can buy the one spouse out, but it's still their 50% based on the equity. However, there's other times where you can't come up to any type of decision. So what's going to happen is your property is going to be sold. It's going to have to be sold. But there are certain situations where a party can get exclusive use and control of a family residence because they have custody of the children. So there can be an order from the court where it states that until the youngest child turns 18, the house cannot be sold. After that child turns 18, the house can be sold. Half of the proceeds will go to her, half of the proceeds will go to him. That's it. But if it's community property, the law says 50-50. So if you feel you've given more financially, that doesn't matter. It's still a 50-50 community property split. I hope that I gave you guys some good information today, and I just really want to let you know again, my name is Rikisha D. I am an attorney in the state of California. I've been practicing for almost 10 years, and if you have any type of questions, you please feel free to call me or call my office. as well as visit our website so that we can assist you with all of your family law needs. We are here to help you. We are here to help you navigate through the process, whether it be divorce, child custody, or a restraining order. So please don't hesitate to call us for any of your family law needs. Thank you.